Hey everybody, welcome to another episode of Ask Me Anything with me, Yaasha Sabba at Sky Unlimited Legal Advisory. That's skyunlimited.law. Question of the day. A family member of mine, the person asking this question, was bequeathed a house from a living trust. He didn't claim it because he doesn't want to work, and so he can get Medi-Cal coverage, or in the United States, Medicaid, to cover the medical care he needs. Is there a way to claim the house from a trust and then transfer the deed to someone else without affecting his qualifications for Medi-Cal or his taxes, etc.? This is a very interesting question, which is why I wanted to talk about this. So when we talk about Medi-Cal, or in the United States, it's called Medicaid. Here in California, we call it Medi-Cal. We're thinking, a lot of people think, oh, that's health insurance. If you can't afford to buy your own private insurance, you can get Medicaid or Medicare Part D, and then Medicaid or Medi-Cal will pick up the difference of what you can't afford. But there's also another reason why people get Medi-Cal here in California. One reason is long-term care. What happens if you reach your 80s, your 90s, you're no longer driving, and you want to be independent, but you don't have so much money because you're not working, you're retired, you've been using your retirement money for your living, and you need someone to help take care of you, go to the grocery store, clean your house, take you to the bank. That's either going to be done by your children if you have children, or you're going to Uber around and you're going to be paying your own money to take care of that until your money runs out, and then you need the government to help you. And usually when we do planning for individuals, we can plan where you could save your own money and use the government's money without going broke. Or you don't plan, you use your own money, and then you can go on the government's money. The government's money is Medi-Cal, also known as Medicaid. So what happens when you start getting on those programs? If you or a loved one of yours is on Medi-Cal, there is a rule that says when that loved one passes away, then any of their assets going into probate, Medi-Cal gets paid back. So here we have an individual who either is on Medi-Cal or wants to qualify for Medi-Cal, and now they don't have assets, but they are about to inherit some assets. If you inherit money from people, all of a sudden the government sees that and they say, uh-oh, you have money now. Congratulations, you have money. We don't need to pay anything. You're disqualified. And even if it's $10,000, which is above the limit, and under our standards right now, if you're a single individual and you want to apply for Medi-Cal, you can't have more than a certain amount of money, a certain amount of income per year. That's like $3,000 a year in income. And you can't have more than, don't quote me on this, I don't know the updated numbers, but I think off the top of my head, it was around like $60,000, $30,000 of total assets, right? So most of the time, as you might imagine, the people applying for these government benefits, they are poor. They have no money. They're in poverty, in essence, right? But that's really not true. I actually help a lot of clients that they do still have a few $100,000 in their name. They have a retirement account, they have a house, but these are not liquid assets, so they can't just sell their home or pull all their money out of the retirement account and pay taxes to be able to afford their long-term care. So we restructure their holdings in a way where they can qualify. So there's a lot of people that are not in poverty. They are part of the middle class, but they don't want to lose all their money to their long-term care, assisted living, nursing home, that kind of stuff. So we structure their assets in a way where they do qualify. The downside, though, is even after all that restructuring, the moment they inherit something from somebody, they can get disqualified. And that disqualification, it's not permanent, but it could last 6 months, a year. And the moment they're disqualified, they're not getting assistance from the government. Now there's a huge drain on their money, and that's very sad. So in this case here, you have a family member who has been bequeathed a home. The first question is, are they going to make that their primary residence? If they're in a nursing home, as long as they intend to make it their primary residence, that qualifies as an exempt property under Medi-Cal. We don't count your primary residence as part of your net worth when we're calculating how much money you have for qualification. But if it's not his primary residence. If he already has a primary residence, this is excess property. The value of this real estate will be calculated as his net worth, and it will instantly disqualify him. So you really have two options. Either you accept the home, you accept the partial disqualification for a number of years, sell the home and use that money to take care of yourself, or you turn that home into a rental property, accept the home, turn it into a rental property, and maybe you don't need government benefits anymore. Maybe you have enough rental income, depending if that home's paid off or not, where that income can support his long-term care going forward. So a financial analysis needs to be done by your family member. Now, if he cannot accept the home in any way, he can't get disqualified, he can't afford to be disqualified from Medi-Cal, and this home is going to make that happen, his only option at that point forward is to disclaim the home. When you disclaim an asset, you are basically saying, I don't want this asset, even though it's an inheritance or a gift and I'm getting it tax-free or whatever. I don't want to own it, and I am going to disclaim it. And if you do that disclaimer of that asset within a number of months, the federal government in California says you have to make that disclaimer within 9 months of that gift officially being made to you. Usually we look at the date of death of the family member that died. The date of death is when their estate plan, their trust says that your family member is supposed to get that home. So 9 months from the date of death, yeah, the clock is ticking. You have 9 months to let the trustee know you don't want the home, you're disclaiming it. If you don't do that within 9 months, the government says, even though you don't want the home, we're counting the home as if it was yours. And whoever else that home went to, it was a gift from you to that other person. And that can trigger the disqualification with Medi-Cal, as you've learned earlier. Time is of the essence for you. You need to disclaim the home if he doesn't want the property and he doesn't see any benefit from receiving that home. If he cares more about getting qualified for Medi-Cal or even Social Security disability, that kind of stuff, then that home might be detrimental to him, right? And he might need to disclaim it. Now, the hard part here is if he disclaims the home, who does the home go to next? Well, the first step is this home is inside of a trust. So we have to go read the terms of the trust to double check and see who this home goes to next, right? Does it go to his descendants? Does it go to other beneficiaries inside the trust? It really matters whatever the trust says. And if the trust is silent on it, then it probably doesn't go to his descendants. It just goes to the next person in line in the trust, whoever the contingent beneficiaries are. So this is actually a little more complex of a decision than you would realize. I believe your family member needs to talk to an attorney, have that financial planning conversation saying, okay, you want to apply for Medi-Cal for either health insurance or for long-term care purposes. We need to do a financial analysis of your holdings and determine if that home can become your primary residence. Is it going to be a rental property, or is it going to disqualify you? If this home were not in a trust and something similar was happening, let's say, for example, just for the audience learning, that this home was in a will. The will says, I want the home going to this family member, and this family member wants to apply for Medi-Cal. Same situation. Does he want it or not? If he doesn't want it, he needs to disclaim it, and he has to do it within 9 months. File the disclaimer with the court, because all the wills go through court. And from there, whoever is the next heir in line or the contingent beneficiary, according to the terms of the will dictate who gets the home next. Your family member cannot say, I don't want this home, but I want this home going to this person instead. That's not how a disclaimer works. If your family member does that, it means he's accepted the home and he's now gifting the home to someone else. And that can disqualify him from Medi-Cal, because the moment he accepts the home, it's now part of his estate, his net worth, the full value of that home, okay? Disclaimer is an option here in order to say, no, it wasn't mine and I am going to maintain my Medi-Cal benefits, but it kind of sucks that he loses that value or that home, that opportunity. So he should talk to an attorney about his financial planning situation, his net worth, how he currently holds his assets, what's his current plan for qualifying for Medi-Cal, and then from there, he can determine, does a disclaimer make sense or does it not make sense? Do we figure out a way where we can handle this? Now, this is what sucks about estate planning. This is one of the parts that I hate, that most estate planning attorneys don't look into. First off, a lot of estate planning attorneys, they focus on the client and they help the client build an estate plan, but they don't focus on the beneficiary or the possibility that one day a beneficiary, any beneficiary, might end up in a medical situation where they need government benefits. What happens if a beneficiary becomes a paraplegic? They were normal people like me, healthy, strong as an ox, but then all of a sudden they get in a car accident and now they're paralyzed. And their physical therapy and medical bills cost way too much money that they need to apply to the government for extra funding from the government to help them pay for their long-term care, their disability services, their physical therapy, all of that, right? If all of a sudden a beneficiary is in a life situation where they need that, and that was never anticipated in the estate plan, and now mom and dad dies, and now mom and dad are leaving that beneficiary tons of money, that's great. The beneficiary has money, but now the beneficiary's government benefits are disqualified, and now the beneficiary is relying on that inheritance to pay for everything. Rather, instead, what the attorney or your family members should do, and this is where we need to look at the trust and see if this option is available for your family member for this home. What I like to do for all my clients is I don't like to assume that beneficiaries are going to be healthy or they're going to need government benefits because of their long-term care, their medical care, whatnot. So in almost every estate plan I draft, whether it's a trust or a will, we create what we call special needs trust provisions. What does that mean? That means there's language in the client's estate plan that says executor, trustee, whoever is in charge, in the event one of our beneficiaries is on needs-based government funding or aid, then they will not get the assets distributed to them directly, which can disqualify them from that aid. Instead, trustee, executor, you're going to build a special needs trust for that beneficiary. You're going to put the assets in there, and by doing that, the assets, because it's in a special trust with special language, is now exempt from their net worth calculation, exempt from disqualifying them. Basically, we can maintain them as qualified beneficiaries of the government aid and give them assets in trust that's there to protect them. Why does that matter? Some people say to me, well, Yaasha, if you're inheriting money, you shouldn't stick with government funding. You know what? You're right. I agree with you. We should not rely on the government when we have our own funds to take care of everything. But here's the rub. Life is complicated, okay? Life is very expensive, especially out here in California. And by the way, the government doesn't pay for everything. The government might help subsidize your insurance. The government might help pay for your long-term care, the nursing home, assisted living, a health home aide to come into the home, clean up the house for you, but the government's not going to pay for your vacations, gifts to your grandchildren's, going to the movies, taking an Uber to go to a haircut, maybe, but not completely. So you still need your own money, your own assets to live a happy life, a quality life. The government gives you enough money to survive. And honestly, survival does not mean happy. It just means you're alive and you have this basic care, but you really can't do anything else because you have no money to do anything else. So that's what being able to restructure your estate when you're qualifying, it's about maintaining affordability of your long-term care or medical and maintaining a happy life so you don't drain your own assets. And same, if you inherit, putting that inheritance in a trust so it doesn't get wasted on medical care and long-term care because the government's there to help us with that. And then the rest of your assets in trust are there for everything else, your happiness, your vacations, renovating your homes, all that kind of stuff. And then from there, whatever's left over, that can go back onto your loved ones, not drained by your own long-term care. Do you see that? So there's a huge advantage. We call this long-term care planning, and it is not a common thing that most estate planning attorneys know. It's actually very niche. There's not a lot of estate planning attorneys that know how to do this, but they're out there. You just have to find them. And right once you have that long-term care planning, now, if we hope that the clients that passed away and they have this trust, let's go and read the trust and see, did they include that special needs trust language? Maybe all this worry over the house is no worry at all because the trustee can create a special needs trust and put the home in it, and it is exempt from your family members' assets that they don't have to disclaim the home. The downside with that is I don't know. We have to read the trust. Again, you need to have an attorney review that trust and your family member's interest in it, see if there's special needs provisions. Not common. It's something common I put in. Like I said, I don't like making assumptions. We put it in anyways. But not every attorney does that. Not every attorney thinks about that. Okay, so time is of the essence. You only have a certain amount of time to disclaim the asset. Make sure your family member goes and sees an attorney immediately to figure out. That way they don't get disqualified or make a mistake, causing them to accidentally get disqualified, because there's no reversal there, right? From government aid to take care of that. If you have any questions or need any further advice, I'm more than happy to help. You can just always give us a call. Email us at info@skyunlimited.law. For everybody else, send your questions to us. We're more than happy to answer them and educate the community. We deal with long-term care planning, Medi-Cal planning, estate planning, trust planning, all of the above, even tax planning. With if you don't have necessarily a Medi-Cal problem, you have a tax problem, like you have too much money, more problems, we're happy to help. All right, I'm going to sign off. Everyone have a great day. Stay safe. Take care. Bye.